Would you state your name for the record, sir?
My name is Frank Michaud. I am the beneficiary of the Frank Anthony Michaud estate that you are administrating over, and I appoint you as the trustee for the record. Let the record show. I am here as a appearance, not general. And I am here on the rest of coercion.
Thank you, Mr. Michaud. Today is the day and time scheduled for the preliminary examination. In this matter, there is count 1, weapons, firearms, possession by felon. Count 2, carrying concealed weapon. Count 3, felony firearm. Are the people prepared to proceed?
We are, Your Honor. We do have a couple of preliminary matters.
Before we do that, Mr. Michaud, are you prepared to proceed?
No, ma'am. I'm actually here to get a better understanding of things first.
What is it that you need to get a better understanding of, sir?
For one, is the jurisdiction that the court is operating upon.
Judge, I'm going to object. The court has made a decision on this motion previously, both you and Judge Oakley on this, so I'm going to object.
Mr. Mohammed, hold on one second. Mr. Mohammed, what we will do is let Mr. Michaud make his record.
Yes, ma'am. Okay. Constitution, the 6th Amendment grants me the right to know the nature and the cause of the action. And I know the jurisdiction that you're operating upon for the record.
The next thing, sir. The next thing. You said you had some preliminary matters, which suggests more than one thing.
Oh, yes, the jurisdiction of the court.
Buckle up, because this is where the courtroom energy shifts fast. The defendant opens with sovereign citizen language, refusing to identify himself in a normal way and declaring special appearances and trustees. The judge allows him to speak, but the imbalance is obvious. Instead of answering basic questions, he tries to control the room with word games. This moment matters because it signals early on that logic and procedure are about to clash head-on. And
I also want to, with the basis of that answer, I would like to address some other things as well.
What other things, sir?
It's pertaining to off your answer. So,
Mr. Michaud, I think we had this conversation last week. Correct me if I'm wrong. This is a criminal case. It is alleged that on February 23rd, 2021, at Metro Airport, which is located in the city of Romulus, you committed the following: that you did possess and or transport and or purchase a firearm when ineligible to do so because you've been convicted of violation of Controlled Substance Act 333.740124 4012A4, a specified felony, and the requirements for regaining eligibility had not been met. Contrary to MCL 750.224F, count 2, carrying concealed weapon, that you did a pistol, whether concealed or otherwise, in a vehicle operated or occupied by said defendant, to wit, a Range Rover, contrary to MCL 750.224. Count 3, felony firearm, that you did carry or have in your possession a firearm, to wit, a pistol, at the time you committed or attempt to commit a felony, to wit, felon in possession of a firearm, contrary to MCL 750.227B. There's also an habitual offender third offense notice on the file where it's alleged that you were convicted of the offense of violation of Controlled Substance Act on October 24, 2013, and convicted of the offense of attempt carrying of a concealed weapon on April 30th, 2002. That being the case, the court having responded to the charges indicated to you that this is a criminal matter. The court's question back to you, sir, is are you prepared to proceed with the exam in this matter?
No. You still haven't stated the jurisdiction of the court for the record.
Didn't you just do 30 days for being willfully ignorant and asking the same question over and over?
Here's where reality starts pushing back. The judge carefully explains the criminal charges, listing the firearm offenses and prior convictions in detail. Rather than responding, the defendant ignores the explanation and loops back to jurisdiction again. The court stays calm but firm, making it clear this is not civil, commercial, or theoretical. This segment shows the court laying groundwork while the defendant refuses to engage with it.
The court is the 34th District Court to you before, sir, and I will renew that indication to you. Are you prepared to proceed with the exam?
No, because Oakley stated that the jurisdiction of the court was Michigan statutes, and that's not what you're saying today.
Chief Judge Brian Oakley, you had having a conversation, well, we're having a hearing today, and sir, we're doing one of three things today. We are proceeding with the exam, you're waiving the exam, or we're adjourning this matter. Your response to my question right now is one of those three things. What are we doing this afternoon?
And you said, you also stated that you addressed me having questions, and I had another question pertaining off your answer, and I wanted to read that.
Mr. Michaud, no, we're not doing this afternoon. Exam?
Rest and coercion. I would like to appoint Mr. Sullivan as trustee.
Mr. Michaud, you're not under any threat. This is a court. You've appeared this afternoon. This case has been called, and if you're prepared to proceed with Mr. Sullivan sitting to your left, this court will proceed. Is that what you're indicating?
Well, you say I'm not under threat, right? And if I continue to ask a question, I will be held in contempt, which is a threat, right?
I never said contempt, sir.
Well,
What we are is.
At this point, the court stops entertaining the circular talk. The judge gives 3 clear choices: proceed, waive, or adjourn. Nothing more, nothing less. Instead of choosing, the defendant claims coercion and threats that are not happening. The judge cuts through the noise and reasserts control. This part is crucial because it marks the shift from patience to authority, with the court steering the hearing forward.
Scheduled for a hearing, and what this court does is hearings. And I entertained some of your questions, but it is now 2:15. And the court's, I know, sir, but I'm presuming that there will be some testimony.
okay, but you're asking me, am I ready to proceed? And you, while you asking me, you also telling me that we're about to proceed. So you're not actually giving me the right to answer the question. You also making it seem like you're threatening me. So,
Instructing you to tell you that I'm not threatening you,
okay,
but I've answered all that needs to be answered from this court to proceed with either the exam, a waiver.
Okay, all right. But you haven't answered the questions that I have asked. I said I had another question, and you're still not allowing me to ask the question. So do I have the right to ask?
What's your question, Mr. Michaud?
I just want to ask you, far as, I want to read this for you.
No, sir. You had a question. What is your question?
Can you help me understand this? Okay, according to 27 CFR 7211, it say all crimes are commercial and must have nature and cause and be prosecuted in the name of the people of the states as a real party and interest, not the people of the state, the corporation, the fiction. This is 20 FCFR, right? So I'll need you to elaborate on this code for me, please.
Mr. Michaud, this court will decline to elaborate or respond to that because this afternoon we are here to determine if the prosecution is able to show that a crime has been committed and that probable cause exists to believe that you are in commission of that crime. That is what we're doing this afternoon.
I understand, but it says that possession of a deadly weapon is a commercial crime. So we have to I need to have a better understanding if this is a commercial crime. You said this is a crime, and
now the argument dives fully into internet law territory. The defendant starts quoting federal codes, insisting crimes are commercial and require an injured party. The judge shuts it down cleanly, refusing to debate irrelevant theories and restating the narrow purpose of the hearing. This moment highlights the disconnect between online legal myths and actual courtroom procedure, with the judge keeping the case grounded in reality.
There is no injured party where I hurt anyone. You haven't gave me the right to face my accuser, and it tells me under this code, 27 CFR 72.11, all crimes are commercial. A deadly weapon is considered a commercial crime. I understand that commercial is civil, but you're telling me this is criminal. So how is it criminal? And it says if there must be an injured party for the injured party, and you haven't presented an injured party for the record. So, I mean, can you elaborate on what jurisdiction you operate under? Is this civil or criminal? Because it doesn't make sense.
Last week and just now, you indicated a right to face your accusers. And you indicated that the court will be presenting something. The court is not presenting anything. The court will take testimony this afternoon and review evidence, documents, video, or Mr. Sullivan on your behalf presents to this court. You want the right to face your accusers. I don't know who Mr. Mohammed is calling to give testimony this afternoon. I don't know who, if anyone, Mr. Sullivan is calling to give testimony this afternoon. That being the case, sir, are you prepared to proceed with the exam?
Okay, so
the standoff becomes obvious here. The judge explains how accusers, testimony, and evidence work in criminal court, step by step. The defendant still won't give a straight yes or no about proceeding. Every response becomes another detour. This segment shows the power dynamic clearly. The court remains steady and controlled while the defendant talks himself deeper into a corner.
Chief Oakley said that he stated for the record that my accuser was the state of Michigan. And here in this code, it says, the prosecuted in the name of the people of the states, not as the people of the state of Michigan. So what he said is contradiction to this code, and it's 27 Code of Federal Regulations 20. So I still I don't understand.
You were in front of Judge Oakley for a probable cause conference, which is basically a scheduling. Are we having an exam? Is there a plea or is there a waiver? For some reason, that didn't hang. Then you were with me for PCC last week. I asked you questions, you wouldn't respond, but I tried to answer your questions. And the people twice demanded an exam. And when you would not answer my questions, I scheduled the exam. Mr. Michaud, your only response right now is yes or no. Are you prepared to proceed with the exam this afternoon?
Well, under threat and threat and duress of coercion, I appoint Sullivan as my.
Mohammed proffered to the court People versus Perkins. And Mr. Sullivan, the court has had the opportunity to review the opinion, and it does indicate that the defendant bears the burden of producing evidence to establish that his or her right to possess a firearm has been restored. That being the case, the court is accepting the certified record that was tendered by Mr. Mohammed. The court also has had the opportunity to hear the testimony of Officer Stempian. And for purposes of this preliminary examination, we'll find that the people have met their burden. And we'll bind Mr. Michaud over as charged. Mr. Michaud, your next appearance date will be on March the 13th, 2000.
This is where everything concludes. After reviewing the record and testimony, the judge delivers a direct ruling. Probable cause is found, the charges are bound over, and the next court date is set. All the earlier arguments disappear in the face of a final decision. If you enjoyed the video, make sure to like it, subscribe to the channel, and we'll see you in the next video.